That's a very bad idea because of a concept called fraudulent transfer and the potential for successor liability. First, let's deal with the fraudulent transfer aspect. If a business has debts and it takes its assets and it transfers it to another business that's just getting started, the clear indication is that it's transferring those assets to hinder, delay, or defraud the creditors involved. That falls within one of the two definitions of a fraudulent transfer. Outside of bankruptcy, when a debtor engages in a fraudulent transfer of assets with the intent to hinder, delay, or defraud the creditors have the right to go to the recipient of that transfer and take the money back to the extent necessary to pay the antecedent debt. So the new business will be left high and dry because it's not going to be able to retain those assets. There is, of course, the second definition of a fraudulent transfer, and that is a transfer is fraudulent with respect to creditors if it's done without getting a reasonably equivalent value in exchange for the transfer. So in that situation, you could somehow argue, well, there was no intent. After all, does a business have intent? Really, only individuals have intent. But we can bypass that altogether by saying, well, this business transferred these assets to this other business and didn't get a reasonably equivalent value in exchange for the transfer. It's therefore a fraudulent transfer. And so the creditors can, well, the term we use is avoid. It means to render null and void. It's a somewhat unusual usage of the word avoid. The creditors can avoid the transfer to the extent necessary to pay the antecedent debt. If that business ends up going into bankruptcy, then the trustee assigned to the case inherits the right of the creditors to avoid the transfer. The difference is when the trustee avoids the transfer, the trustee can avoid the entire transfer, not just a portion of the transfer necessary to pay the antecedent debt. So it's a really, really bad move. On top of that, if the principals just gut the one business, take the assets and stick it into the other, in essence, they're just taking the business without the name and starting it with a different name. There is the very real likelihood that there's successor liability, that this new business is liable for the old business's debts. So if the reason that the old business did the transfer was because it was failing and had a great deal of debt, all that's happened is a little paper shuffling. It's not going to protect the new business from successor liability. The long and short of it is, it's a very bad move. Don't engage in fraudulent transfers. If you engage in fraudulent transfers, there is a Supreme Court holding that says that that constitutes actual fraud, at least in an individual case. So if the principals are doing that and later they want to do a bankruptcy, they may face non-dischargeability of their debts based on that fraud. So long and short of it is, don't do it.